for being here. And yeah, it's Friday morning, last day. There were parties yesterday night, so thank you very much for being here. And so this panel is hosted by eLaw of Leiden University, Center for Law and Digital Technologies in the Netherlands. The panel is organized in the context of the EU DECO project, the Horizon 2020 project about European data economy. I'm Gianclaudio Malgieri, doctoral researcher at LSTS, a bit chair here. So yeah, one of the strongest topics of discussion at Cpdp and privacy conference is explanation, automated decision making, but how to put it in practice. So what really counts is how effective these rules can be in practice and if alternative ways can be more effective, technological solutions, ethical solutions. So together with transparency, we need to focus on accountability of algorithms. And accountability is based on effectiveness. That's why this panel will try to fill accountability holes in the algorithm network. A group of great speakers will discuss it this morning. We have Moderator, Francien Dechesne, who's a researcher at eLaw, on the topic of responsible innovation using data analytics. Then we have Karolina a postdoctoral researcher at eLaw in Leiden. She currently works in Horizon 2020 project eSides on the ethical and societal impact of data sciences. Then we have Lorena Jaume-Palasi, is a co-founder and executive director of the non-profit organization Algorithmic, based in Berlin. And then we have Frederike Kaltheuner, sorry, is a technology policy expert working for Privacy International. You all know Privacy International very well. And Kyle Erickson, who joins us from Washington, D.C., where he's privacy and civil liberties engineer at Palantir Technology. So please, Francien.
Thank you very much, Gianclaudio, for this introduction. In the past few days, we, or at least I, have heard a lot of panels speaking about privacy by design and data protection by design. For example, yesterday in a panel there was a video contribution by Anne Kavukian where she said, well, as long as you follow privacy by design, you get a long way into compliance with the GDPR. However, I do think that by now we all see that privacy by design or other by design strategies are no blanket solutions to solve all issues, especially when it comes to what's referred to as algorithmic decisions. And we do realize that the term algorithmic decisions may spark a lot of debate, and some of our speakers will also address that. But reasons why the by design strategies, and especially privacy by design, will not be the blanket solutions for all issues that are raised by algorithmic decisions is that, well, for example, not all issues are just about privacy or data protection, as we all know and as will be illustrated in this panel. And also that we have come to realize that when we look at new technologies, you can partly look at it as social experiments. So not all uses and not all issues can be anticipated in advance. And in particular, that means that we cannot address all of the harmful and undesired effects by design, because that means that we have to anticipate it. Accountability is a broad regulatory strategy that respects that not all issues can be anticipated and prevented, and allows us to provide ways to act and learn in case of undesired or harmful impact. And the case of algorithmic decisions, as we use the terminology, raises many questions about where to locate and how to meaningfully assign accountability in the network that constitutes such decisions and the context that co-determines the impact. So in this panel, we hope to address problems in identifying where to assign accountability, and we will be looking for constructive ways of filling such accountability holes. We have different perspectives at the table, and we're very happy to have this excellent group of panelists from academia, policy, and industry. And the way we are going to go through this subject matter is that we will walk the spectrum from the academic, conceptual, gradually to the practice of business. And So I'm happy to first give the floor to my colleague, Karolina, who, as Gianclaudio mentioned, is a researcher at eLaw in a project on ethical and societal impact of data sciences. And she will give an introduction from a more abstract academic perspective on the notions of accountability mechanisms and algorithmic networks.
Thank you very much, Francien. Can you hear me? Oh, okay. Thank you for this introduction. Let me show my slides. It's not coming. There's something wrong, I think.
There we go.
There we go. Perfect. So, let me start with a couple of examples about auto-tagging, fake news, and false positives within law enforcement. You might have heard about that black people have been tagged as gorillas, or the Dachau concentration camp has been identified as a sports center. Or if you have the search result for unprofessional hairstyles, you end up having only Afro, or mostly Afro-American hairstyles. Within the context of social media, it's often spread that fake news has no limits, and there's no possibility, even accountable possibility, to prevent, for instance, social network sites from spreading this news. And furthermore, within law enforcement, we came across that there are a lot of false positives through algorithmic decision making. One example is from John Grass, an American citizen whose photo has been associated with a criminal, and this resulted in that his driver's license has been revoked. And the other example is a Canadian child, because in Canada some children are flagged as security risks, and their name is matching a terrorist list. So why is accountability needed? Basically, accountability is the ability to hold parties liable or responsible for their handlings, to ask for explanation, to remedy or compensation, and basically to open debate and keep it debatable whether something is legitimate or not. But what if this ability isn't there, or it's undermined, or just simply not facilitated? Then we could say that we have an accountability hole. And how can accountability holes occur? Many reasons are there, but I just would like to focus on 3 of them. One being that algorithmic network objectivity is a myth. The second is that the role of algorithm is often singled out. And the third one is the temptations of algorithmic innovation. So when I talk about that algorithmic network objectivity is a myth, I would say that algorithms register searches, learn from searches, and searching individuals are mostly subjective. Therefore, searching is a highly normative process, and machine learning itself is normative, so there is nothing objective about it. The second, that the role of an algorithm is often singled out. We often came across that it's blamed only on the algorithm when something goes wrong, right? But it's in fact very difficult to identify actual responsibilities. And instead of singling out one party, it could have been useful to have a more comprehensive approach. The third one, the temptations of algorithmic innovation, obviously are vast. Legal limits cannot catch up, ethical limits are difficult to set or enforce, and algorithmic innovation itself creates new challenges for accountability. So how to fill accountability holes? I would suggest some examples, and I'm very much looking forward to the other speakers, what their idea is about them. First, by improving law, of course. We have the new data protection regime, which is really a big step forward. And it mainly affects privacy by design, and not directly accountability, but it facilitates accountability mechanisms, for instance, by such rights as the right to explanation or right not to be profiled. The second one, by parliamentary debate. Luckily, there is still place for seeking parliamentary debate regarding issues such as, I mentioned earlier, the no-fly list for kids in Canada. One of them, this little boy, initiated, with the help of course, of his parents, a parliamentary debate about whether this is justifiable to keep children asked multiple times because their names seem to match one of the terrorists on a blacklist. The third one, technological design. Of course, privacy by design is an example, but it's in itself not facilitating directly accountability. With eLaw, we are involved with a project which is called eSides, and eSides is focusing on the social and ethical implications of data scientists, social and ethical implications of privacy-preserving technologies more specifically. And we basically do a helicopter view above currently existing privacy-preserving innovations and projects. And we came across one project, the Aegis project, who is providing privacy preservation. But for them, privacy preservation means groups anonymization specifically. When we asked them, so what is that you do with it? They said, we offer it to our customers, to your users, and we leave it up to them what they do with it further. So we still see that there is an accountability hole in there. By education and raising awareness, of course, we need to become more tech savvy, and we need to become more value sensitive in order to be able to flip or game algorithmic decisions or algorithmically mediated injustice in certain cases even. And by journalistic publicity, I would say all those examples I raised at the beginning are still demonstrating that we need journalists, we need them to show what's going wrong and when it's going wrong, eventually when algorithmic decisions are negative or offensive for society. So conclusions and thoughts to discuss. Let me pause a little bit here. But we can still conclude accountability in algorithmic networks is absolutely not a pre-given, but requires continuous aspiration and efforts from multiple stakeholders of the whole network. And this is needed, for example, to answer such questions as how to address unforeseen algorithmically mediated prejudice if the machine learns from us. So thank you very much. I would be very happy to continue this panel and listen to the other speakers.
Thank you very much, Karolina, for bringing up these interesting examples of accountability holes in algorithmic network with the offensive auto-tagging, the fake news ads and false positives, and also providing some possible ways forward. I don't think you explicitly mentioned the role of NGOs.
Yes.
But we're very happy to have a good representation of two different NGOs here at the table. And we are very curious and interested to hear the perspective of the NGO Algorithm Watch, based in Germany, but active, I think, more internationally as well, on how they analyze the complicated concepts around algorithmic accountability, or accountability in algorithmic networks, what they see as best practices, what their experiences are, and what we can learn from accountability mechanisms that fail. So I would like to give the floor to Lorena to address that.
Well, thank you very much for having me here, for the invitation. I don't want to get too much into details because I'm really looking forward to the conversation that we will have afterwards. So I just would like to introduce very shortly what we do, who we are, and how we approach this whole issue about algorithmic accountability. So our name is Algorithm Watch, and we feel sometimes that people may expect that we are an organization against algorithms, and what we usually say is we are like Food Watch. We're not against food. We do think that there is an added value in automatization processes. So just to make things clear for the first thing. And of course the name is a bit populistic and it's not accurate, because what we think that we need to look at is at the whole decision structure that is being built upon an automatization system. And sometimes part of that structure has to do with the algorithms. Part of the structure has to do with the data that you're getting and the whole flow of how this data is getting into the system, which data are you selecting to get to feed the algorithm, and how you are managing and are managing these different data points that you might have to operate the whole system. And sometimes it's a question of something that has to do nothing with machines, but of a bad designed process. Just to put an example, to have a better idea of that, in the 2000 years, banks in Germany, when someone would come to the bank and would ask for a credit, the bank will send to the scoring company in Germany. There's one scoring company in Germany that's very well known. They're very big, and they are the ones doing the scores for almost all banks. So those banks would send a request to that scoring company. And on the 2000, a new profile of person asking for a credit would emerge, the smart user, so to say. That would be the person that would go to different banks and would ask to different banks about the conditions to get a credit. And every time that person asked those banks would send a request to the scoring company, and that would add to his profile, so that this type of smart users in the end would have a problem, because of course by the fifth bank they will be asking, the score would have gone pretty much down. So the problem was not in the algorithm. The problem was that, of course, you should design that in such a way that you might, as a bank, want to ask the scoring company what's about the score of this person, the score value of this person, as a condition request, and not as a real request of asking a credit, so that the bank accountant can tell the potential customer, well, considering your scoring, these are the conditions that we can offer you, and so on. But this request should not count as a real credit request. So this is one thing where you can see sometimes what you need to look at, it's not in the algorithm and it's not in the data bank, but it's in the design process. But what we also do, what we actually do, just to put an example, are trying to put some light and some more transparency in this realm of algorithmic usage. So right now we are closing a campaign we started during the German elections. We got money from 6 different media regulators in Germany, because that's a federal construction in Germany. The media regulator is in the Bundesländer, and 6 of them team up and gave us money for us to take a look at the Google News and the Google search algorithm. We had a media partner, the Spiegel. Spiegel is a big newspaper in Germany, so we got over almost 5,000 people that would join our campaign. What we did is we crowdsource. We created a crowdsource project, so to say. We created a plugin, and everyone willing to help us would donate their data. How? They would download this plugin, and with that plugin, we would be able to collect the results of their Google News and Google Search request 6 times a day. And how would we do that? We wanted to take a look at whether there is how much personalization does Google News and Google Search have. We assume that if there's a high degree of personalization, results would be very different by using the same request keywords across the whole country. And that was the assumption. And what we did is that the plugin would open a browser and would search for 16 keywords, 6 of them being the election candidates running for chancellor, and the rest being parties, political parties. Now, that is not an ideal design. Now we think we would do that differently, but what we did is we let the plugin get the results. We got over 6 million search results, and we took a look at how much this degree of personalization in comparison with a slightly more regionalized way of so to say, of clustering results. Okay, and this is one of the things that we did. And the second thing that we are doing right now is we got money from 2 big foundations in Germany, and we are going to do, or we're starting to do, a mapping of all algorithmic systems being used in society within Europe. And we're going to have an additional dimension to that. It will not be a mapping also about the systems, but also about the regulation that is being used to regulate automatization processes, and also the actors involved in this realm, meaning with that companies, but also academia, regulators, NGOs, etc. And those are things that we are trying to do as a practical way to shed more light on what is being used, putting more facts and figures in this space, because we think that we have a lot of examples coming from the US, but we don't have many examples coming from the European continent, although there is a lot of things happening in Europe. There's a lot of automatization happening already. Thank you very much.
Okay, thank you very much, Lorena, for this perspective from Algorithm Watch. I think your example of the plugin demonstrates that, so I made a plea for accountability as a regulatory strategy, but the example of your plugin demonstrated that for some accountability mechanisms, you actually require to gather more data, and that accountability might be a tension at principles like data minimization, and so there's interesting tensions there, and maybe I could use that a little bit to bridge over to our next NGO that has privacy in their name. So that maybe Privacy International can shed a light on how here it is. On how these tensions between accountability as a way of keeping track of what people did to fulfill their responsibilities, how that relates to principles that are, for example, in the GDPR, trying to minimize use of data, where accountability might require use of more data. So I would like to give the floor to Frederike Kaltheuner of Privacy International. As a representative of Privacy International, she has given expert evidence on Internet of Things, artificial intelligence, and big data in the European Parliament, as well as the House of Lords. So I think you are a person who can speak in the solution of having parliamentary debates, and I would happily give the floor to you to talk about your experience.
Thank you very much. I would like to start out without dwelling too much on definitions by saying which aspects of this problem we are looking at specifically as a privacy organization. We make a distinction between, on the one hand, profiling practices, and with this we mean the use of algorithm not necessarily to sort, score, categorize, assess, evaluate, and risk individuals and group. On the one hand, so this would be things like individual level threat scores in policing, credit scoring, but also categorizing people into, let's say, creditworthy, not creditworthy, reliable, not reliable. And also the use of profiling to derive, infer, and predict information. And with this we mean, for example, studies that show you can infer people's personality traits, whether somebody is neurotic or depressed, based on data traces that have nothing to do with what is being predicted. The other dimension we're looking at are decision-making practices that can be based on profiling. With this we mean processes in where automatically decisions are being made, or profiling informs decision-making to make or shape consequential decisions for individual groups and their environment. And I want to take a step back. There are two ways in which we define these problems, which are slightly different from some legal interpretations. On the one hand, I think it is important for us to say we make no distinctions between automatic decisions and the use of profiling to inform decisions. And the reason for this is the following. If you have a scenario, you can automatically make for example, you have a scenario where a system makes the automatic decision to arrest someone. We would all feel very comfortable with this scenario. But very frequently, scoring is being used to then make human decisions. But if the human decision maker is in no ability to interrogate or critically assess the score that is being given to them, this can also result in harms that are quite similar to automatic decision making. I think it's also important to look at the harms. I've highlighted harms on the individual level. There are, of course, societal harms as well. On the one hand, the harm we are concerned with is privacy invasion. So in a way, when predictions and inferences are too accurate because they find out that you are in fact neurotic and depressed or happy and wealthy. On the other hand, it is the misidentification or misclassification of individuals when you're being profiled in a way that does not reflect reality. And this can be both to your advantage and disadvantage, of course. One example I would give is a face recognition mismatch, but it could also be, for example, you're a man, you're being profiled as a woman, and as a result, you only see advertisements for lower paying jobs online. It's also important to talk about stereotyping. Profiling is a kind of logic that's inherently probabilistic. It only ever says that you're very likely to be a threat or you're very likely to be a terrorist. So there is the risk that this results in stereotyping, biases, discrimination. And finally, I think it is important to talk about power imbalances. This is often done opaquely, without our knowledge or consent. And the decision-making or the problems of decision-making, there are two dimensions of this. On the one hand, it is the outcome of the decision, and it is also the process of making the decision itself. One thing I would like to add, a couple of years ago, an academic came up with a framework that I find quite useful. On the one, to classify harms. On the one hand, it is the harmful outcome predictable by the designer or not? And is it discoverable by the public? A lot of the examples that we discuss in the public are examples of harm that were not predicted by the designer, but that are very visible. For example, the misclassification or racist classification of people on Flickr was probably not intended, but is very visible. So as a result, some of the scenarios that are most dangerous are where harm was not predictable by the designer, and it is not easily discoverable because the decision has been made in the background or opaquely. Sometimes we think that these problems are radically new, and it is important to recognize that there are existing frameworks. On the one hand, there is data protection, which introduces a form of accountability principle, which is new. There's also definitions of profiling and automated decision-making. However, we also have to talk about sectoral regulation. A lot of attention has been on the French administrative law that regulates how automated decisions can be made in the French public sector. New York City is looking into setting up principles that go in a similar direction. And there are also sectoral regulations like the Fair Credit Reporting Act in the US that have impact on these problems as well. There are also discussions around industry codes and standards. I didn't put this on the slide, and I did this on purpose, in that we do have a number of positions as an organization on these issues. The first one, which I already mentioned, is that we should not be too distracted by automation itself. Sometimes the harm can be equally severe if profiling is used to inform a decision that a human being makes. We think that data protection should be as strong as possible, but it is clearly not enough to regulate all these issues that we are discussing here today. On the one hand, Article 22 on automated decision-making is extremely narrow and will only apply to very specific situations. So as important as this regulation is, this will not solve many of the problems that we're discussing. The same applies to profiling. GDPR talks about individual profiling that does not capture a lot of cases where people are being profiled indirectly by being put into a group, for example. Data protection is also not sufficient because not all harms result from personal data. A lot of times you are affected by a decision that has not been made based on personal data but can still be severe. The second point I'd like to make is that challenges are often context specific. There are scenarios where we have no tolerance for errors. The example I'd like to give is profiling for advertisement, which can result in harm, versus profiling in a national security context. So different contexts require different solutions. There are some technical fixes, such as making systems more explainable, but we also have to recognize that profiling and automated decision-making come with inherent problems and are not always appropriate in all contexts. They create a probabilistic knowledge, and there are always margins of errors. And in some contexts, we don't feel comfortable with having even a very small error rate. Finally, I would say we have a fundamental problem with the fact that environments are increasingly geared towards our assumed interest based on profiling. So what needs to be done? I think what we have been active in is ensuring a very strong enforcement of data protection law. We've contributed to the Working Party guidance on profiling and automated decision making, and I think this continues after the regulation enters into force. We need to find strong test cases to make sure that this law is actually enforced in the strongest way possible. We also need to collect and highlight case studies on what we call human rights critical AI. So we need to find a list as NGO, as civil society, a list of cases where we find that harm is very significant or where we maybe do not feel comfortable with using systems at all. And we also need to develop sector-specific recommendations. One example which is important is the use of automated decision-making in the public sector, but there are other sectors where I can think of the need for very specific guidance as to what kind of explainability we need and what would make such decisions more accountable. And the last slide is, if you would like to read more about this, we've just published our guidance on the Article 29 Working Party profiling draft guidance. This is how we would like to see the GDPR interpreted to offer strongest protections. We're also working on a paper together with Article 19 on the human rights implications of AI, where we will work out exactly where existing laws fail and come up with recommendations as to what we think needs to be done. And we will also publish a range of case studies and examples that highlight how profiling can be used to identify individuals, to infer information about individuals.
Thank you very much for this great bridge from the legal, the academic, conceptual perspective to the practice. How do these concepts work out in practice? How can we make them effective? And that is actually a very good bridge to the business side of the network or of the spectrum, because companies like the company that we have represented here at the table, Palantir, they have to act in, they have to respond to these requests of accountability, and they are looking for ways how to do that. So things that you mentioned, like making a list of harms or providing more insight in what profiling forms are, I think are things that a company like Palantir is looking out for. So I'm very happy that we have Palantir represented at the table in the person of Kyle S. Erickson. He is a privacy and civil liberties engineer at Palantir Technologies, and I hope he will say a little bit more about what that role entails in the organization of Palantir. As Palantir provides services to companies and institutions rather than consumers, the company may be less visible to the general public, but as people here know, the fact that law enforcement and governments are among their customers means that the questions of accountability and a notion of algorithmic network is maybe even more to the point for a company like Palantir. So we are very much looking forward to hear from them, and maybe first to hear what it means to be a privacy and civil liberties engineer. I give the floor to Kyle.
Thank you very much for that introduction. Thank you also for the opportunity to participate on this very interesting panel. Would you mind passing the... All right, thank you. So first I want to briefly introduce Palantir. I expect it's a company that you may not be very familiar with. Palantir was founded in 2004, and we're an enterprise software company. We make software products that organizations use to integrate, manage, and analyze their data, typically large volumes of data, and typically data that comes from many different sources. Importantly, we're not data brokers. We don't collect data. We don't sell data. We are processors with respect to our customers. So we help them process data for the purposes that they specify and for the uses for which they're authorized. We do have a lot of experience in highly regulated industries and in very sensitive spaces. So industries like financial services and insurance, law enforcement and national defense, dealing with sensitive data like health information, personal information. And so really from the company's inception, we've been very attuned to the privacy and data protection challenges associated with doing this work, and in particular, regulating this scope of authorized use. So our customers are authorized to use this data for some limited set of purposes. And actually, our customer success depends upon their ability to really earn that trust that has been given to them to use this very sensitive information. And so one of the ways that Palantir approaches that problem is by maintaining a team of dedicated privacy and civil liberties engineers, which isn't to say that we're the only people at the company focused on these problems, but rather that we have a special mandate to focus on them explicitly and in a wide-ranging way. So the team is interdisciplinary in its composition. It includes both software engineers and lawyers, and also people who have humanities or philosophy backgrounds, such as myself. It's also multifunctional in that we both support particular customer engagements, so particular implementations of our software and for particular use cases. We also work directly with our product development teams to develop requirements, define requirements, and design and implement new features for our software. And then we do a fair amount of engagements like these with civil society and with the broader privacy community to discuss some of the issues that we're seeing and also to learn from some of the really excellent research that's being done in these areas. So the focus of my remarks today, I want to focus primarily on the problem of human accountability, although I know that our focus here is primarily on algorithmic accountability. Palantir was really founded not so much out of enthusiasm for automated approaches, but out of an appreciation for the limitations of fully automated approaches to the kinds of problems that we're interested in solving. So the company's original mission set was focused pretty narrowly on the counterterrorism problem. And the company was founded really in the wake of the attacks of September 11th. And we recognized very quickly that the counterterrorism problem was not something that was going to be amenable to automated analysis. Automation there was neither desirable nor feasible. Not feasible because counterterrorism, as in many other kinds of problems, involves an adaptive adversary. Adversaries who are intelligent, who can recognize when patterns are detecting their behavior. They change the behavior to escape detection. And not desirable because in these kinds of high-stakes situations, you actually want a human being to be able to be held accountable for any decisions that are made or any action that is taken. And so that fundamental belief that there are limitations to algorithmic approaches has informed the way we've operated our business. As the company has grown into different domains, of course, there are some limited areas where these kinds of techniques are applicable. And so we have a kind of general approach for those particular use cases. I'm not going to focus my attention here in part because I think there's so much work, excellent work being done in this space that we've certainly learned from and we hope to contribute back to. But just to hit the high points here, primarily it's about recognizing that data science and the development of algorithms does not happen in a laboratory or in a vacuum. It happens in real-world contexts and has actual impacts on people's lives and their well-being. That there's increasing concern and fear in the public about, and justifiably so, about the amount of data that's being collected, about the increasing efficiency of algorithmic approaches, and about the opacity of those techniques. Certainly are aware of the normative considerations that are related to these different applications, but also aware of how difficult it is to define or rigorously formalize a set of principles that will apply across all cases because these domains are so diverse. And then finally, this recognition that ultimately you need to have a human in the loop, that there needs to be a named individual or set of individuals or an institution that can be held accountable when something goes wrong. There are a number of technical considerations as well that go into the implementation of algorithmic approaches. Again, I won't belabor these points because I think they are pretty well covered by some of the excellent research that's done in this area. But the gist of it is you need to choose the right problem to adopt an algorithmic approach for. Not every problem admits of these kinds of solutions. You need to be thoughtful about the kinds of data inputs that are going into these models, about possible biases in the data that's feeding the models. You need to be attentive to the kinds of outcomes or of the models and testing them against different segments of populations to mitigate disparate impact risk. And then also there's this general problem of interpretability and auditability. But what I really want to focus on is the challenge of human accountability. So the human in the loop who's ultimately going to be making these decisions, how can that person be held accountable for the work that they're doing? The vast majority of the work that we do involves having a human person sitting in a chair interacting with software on a screen. And that person is going to be interacting with data, sensitive data, writing queries, performing analyses. And how can we make sure that their use of that data is proportional to the purposes that have been specified? Just as in the terrorism problem, we don't think that protecting privacy or holding human beings accountable is as simple as creating a button that will magically anonymize data or detect misconduct. It's going to take a combination of approaches, both technical and procedural. Some of the challenges here are that, frankly, auditing use of these systems is itself a big data problem that requires the integration and analysis of frequently large volumes of log data. That there's a real deficit in tradecraft here. The typical uses of audit data are done by security teams conducting forensic analysis. So there's a security incident, they go to log data to figure out what went wrong, but there's not a lot of established tradecraft around how to monitor for queries that aren't proportional to a use case, for example. There are real problems with organizational ownership and expertise. So in many of the organizations we work with, you'll have a compliance office, an information security team. You might have a data governance team that's part of the IT organization. And all of these are stakeholders in the general accountability problem, but none of them might really own it and feel personally responsible for making sure that these kinds of use limitations are enforced. I think there's also too often a focus on process at the expense of outcomes. So a good example here might be DPIAs. I think the DPIA process is an effective one, but the output of that process is going to be a static document that isn't going to be updated necessarily and might just live in a drawer somewhere and not be operationalized. So then just quickly, I will stop. Thank you. Sorry, we'll get to the conversation. A couple of just provocative ideas maybe we can talk about. What about accounting that actually involves counting things? What about systems that might be self-documenting? That some of the data that's produced as an output of these processes might inform how we think about privacy risk, how we measure and monitor that risk, and actually make progress against mitigating some of the real risks inherent in the use of these systems. And with that, I'll stop. Thank you.
Thank you very much, Kyle. It was on Kyle's own request that we kept the panel contributions a little shorter so that there would be room in our slot to have some interaction between the panelists also, because as you may imagine, the backgrounds are from the whole spectrum. So I would like now to open the floor for about 10 minutes for the panelists to respond to each other's contributions. I'll give the floor first to Lorena and then to Frederike.
Well, thank you to all panelists for what you put into the table. I actually don't want to react, but I have more questions. I have questions to Kyle, and because you didn't get into that, and I'm very interested and curious to know about how the accountability process at Palantir is. So, for instance, do the clients, I mean, you prepare the data for them, right? So, so it's way more easy to just look at the data that it's been prepared than to look at the raw data. Do you, as part of your work in your team, do you encourage them, or do you have a process to make your clients look at the raw data? Because this is one source of mistakes, so where you can realize that something's just going wrong. The second question that I would have is, do your clients get to see the code? The third one is, the engineers and the people, the team creating the solution for your client, do they get to know about the whole process, especially if it's a government? Do they get to understand what the intelligence teams from CIA or from NSA or whoever it is, how the whole decision process of those bodies looks like? Because that matters a lot with regards to the design of the solution that you're offering. And what happens if a client quits and says, okay, we would like to use other solution, or we're going to develop an in-house solution? Do you prepare the data? What happens with those data banks that you must have? Do you delete that? Can they transport it to another solution? And the very last question, I don't think it's you, but do you know who's behind the technology being used for social scoring in some regions in China? Because it looks very much like if it's somehow similar to what you're doing. Well, thank you.
So,
a lot of questions.
Yeah. Kyle, if you could try to give a brief answer to that. Frederike has a few comments afterwards.
Sure.
Yes.
So a lot of questions there. I'll see if I get to at least most of them. I think one of the probably important things to illustrate here is that Palantir has a somewhat peculiar engagement model, in that we're an enterprise software company, but we actually send engineers to our customer sites to help the customer implement the software and integrate their data. So that it is a partnership process where we have engineering resources there helping them to model their data and integrate it into the platform. So to your question about the raw data, so typically this data is coming from some source system that the customer already owns and operates. Maybe that source system includes raw data, or maybe some degree of modeling has already been done in the source system, which might be copied over into our platform, or that might be reconfigured. But in any event, that modeling process is a collaborative one. The code that is used to do that modeling is, of course, not closed and inaccessible to the customer. In many cases, the customer themselves are the ones writing this kind of transformation and modeling code. And I think most importantly, the data is our customer's data. It is not ours. So to the question about whether it can be exported or brought to other systems, we have the data in open formats that can be exported and brought somewhere else, because the data is not ours. So we want to make sure that our customers can can do with it what they need to. I'm not sure if that was addressed all the questions, but we can return to some of the ones I might have forgotten.
Okay, let's move through the comments that Frederike wanted to make.
Thank you. I think it's great to have a company here because it makes these abstract discussions more concrete. And I would like to point out profiling sounds very abstract, but it means in practice things like Trump's idea to build a Muslim database. To the best of my knowledge, Palantir is one of the few tech companies who did not publicly declare that they will not build such a database. So with profiling, there's no need to know who's Muslim. You can just infer this from data such as browsing histories, etc., to find out who is a Muslim and put this in a database. So I'd love to hear your opinion about this. I think profiling also includes things like developing tools that show individual level threat scores for when a police interacts with a person. I think this is very problematic and raises not just accountability but broader ethical questions. Another comment I want to make, there's a risk when we focus on technical solutions such as explainability, we sometimes forget to ask the bigger questions. Frankly, there are some very stupid ideas circulating using these technologies at the moment. One would be IBM's very flawed and dangerous idea to build a terrorist threat score for refugees to help governments decide who is a refugee and who is an imposter. Or the recently published study that detects homosexuality from faces. So they are very flawed solutions are being suggested and pitched, especially to governments. And accountability also means being very clear on saying that some of these are not good ideas. And lastly, I think even if software is built and implemented and used in the most accountable way, not all technology is appropriate for all contexts. What I mean with this is, for example, there's an inherent problem if governments rely on proprietary software. This is not auditable for regulators. That's a problem. Do we really want law enforcement to use proprietary software that is protected by trade secrets? Do we really want profiling to determine who's on a terrorist watch list? Do we really want to use this kind of reasoning to make human rights critical decisions?
Sure. So
briefly respond to that.
Sure. So one just a clarification and a point of fact. So our CEO is on the record saying that we have not been asked to create a Muslim database, and if we were, we would not do it. So did want to clarify that quickly. But I think to respond to some of the other excellent points you bring up, there is tremendous risk involved with many of these proposed applications, and that's why problem selection is really the first gating function when you're considering an automated approach. And we take that very seriously as a company. We're not going to do just any project. And for a given project that we do choose to do, we're not going to adopt simply any approach. So it has to be the right problem and the right approach for the right problem. And certainly ethical considerations are going to factor into those decisions. They will be primary motivators in those decisions that get made. So I'd happy to say more about that if there's more that people would like clarity on.
A very brief.
It kept my mind going. I've been wondering whether you have a knowledge of any eventual solutions that potentially failed, but you learned from that and then you could adapt it in a more accountable way. So, because I could imagine as much as algorithmic decision making is try to be probabilistic, probabilisticness includes to me that it can go wrong and it can create harm. And how can you remedy that? So in case you had any experience, would love to hear your solutions.
Yeah, well, I think certainly redress and rights to redress and rights to access are very important. And I think that there is a lot of interesting work that stands to be done on this problem of making, especially scoring decisions, more transparent to the people who are being scored. I don't think that there's an easy solution there, but fortunately I know that there's a lot of attention being paid to it by a lot of smart people who we hope to be in dialogue with.
Thank you very much. And then I would finally like to give the floor to
Yeah,
Gianclaudio.
before giving the floor to questions, if I could collect some provocations towards a policy practical path. You said we have to look for the right problems, and Frederike was addressing the issue of discrimination. So maybe not just look for the right problems, but also look for the right categories. And who defines categories? I mean, that's the problem of accountability. Who defines categories and how we can? So maybe, an idea just as civil society and NGO and academia, just to cooperate also with businesses and find and look for very simple questionnaire where data, which data were used to train the machine learning, for example, or which was the environment in which the machine learning was conceived at the beginning, which was the first design, then how, which is the space for machine learning and the space for human interaction. And then look for, collaboration and cross-checking of, consistency of these answers. And if some company doesn't want to collaborate, there is the beautiful element of blacklist, in which we can, just provocation, but to look for opening this black box in a cooperation between academia, NGOs, and businesses. So, and maybe there are some questions and...
Yes, that's a good. There's a good suggestion that we collect 3 questions and then have the answers. So I saw at least 3 hands. Here, there, and there. And then there's somebody very unfortunate because she was blocked by the microphone. We will do a second round of 3 questions.
I have a question. Kyle mentioned the very general problem of explainability, but we've already been talking about the very specific human in the loop as an accountable person. And how do any of you see this problem of unexplainable systems in a human way and holding a human accountable in whatever place in the loop?
So we collect 3 questions. I must say that for me it was hard to hear the first
Is it
question.
working? Is the microphone working? Really, can you check?
Maybe we don't have a speaker directed to us.
Is this better?
Yes.
Yes.
Okay.
Can you please summarize?
Kyle mentioned the very general problem of explainability. But we've also been talking about a human in the loop as an accountable person. And if this explainability becomes hard on a human level, how do you view the accountable person on any place in the loop?
Okay.
Thank you. Very quickly, one of the suggested solutions was to create a list of all of the AI harms that are possible. And then when we hear from Kyle, the accountability also needs to be with the customer or the client. So what happens when that list just becomes, hey, here's a way that you can harm people with AI as a giant arrow? What do we deal with accountability in that way?
Okay. And then final.
Sort of builds on the previous 2 questions. When Karolina started, she referred to, let's say, liability and responsibility issues. And Palantir is putting that on the human, it seems. So human accountability. I'm really curious whether this panel, who's looked at the material aspects, has also given thought on the more legal question on who is liable if the artificial intelligence or the algorithm, the machine learning algorithm, is deficient, defect, not working. And I'm quite convinced beforehand that the suppliers of that specific software have excluded any liability in their agreements. So I would be happy to hear some views on that as well.
So we will deal with those 3 questions. Then in the second round we'll have those 2 at least. But first, who wants to respond? Frederike?
So in a way, it can be. I'm not saying it is necessarily very convenient for a company to say that the users of the software are also responsible. At the same time, though, to be fair, what do you do if you sell a product and then they make changes? I think it's important to ask not just what kind of human intervention we want in which context, because humans are also very flawed, but also to be very clear on what human in the loop actually means. In our submission to the Working Party guidance on profiling automated decision making, we made it very clear that we think human intervention has to be meaningful. It cannot be a token. And in order to be meaningful, the person intervening has to be able to critically assess the system and to understand its flaws, limitations, and potential biases. Very often this is not the case. So if I see a score and I don't know how the score has been made, there is no meaningful human intervention. And explainability, the other thing is stakeholder and context specific. Regulators need different explainability than customers, than in consumer products. So the key is always to ask, like, what do we need explainability for? We need this in order to interrogate systems, to hold them into account, and different people require very different things. But at the very least, you need to know which data has fed into it, what categories, how they have been analyzed.
Okay, Lorena, you wanted to respond?
Oh,
or
I can go first.
Kyle can go first. Okay.
Yeah, it might be helpful to just describe quickly an example of how this might work in practice. So one project that we were involved in working on was with a large multinational insurer that's based in Europe, and that was trying to get a handle on their fraud problem. So fraud is a very common application for machine learning approaches, but certainly also carries with it some risks. And what this involved was adopting a kind of multi-stakeholder approach. So you had the business that cared about minimizing their losses due to fraud. You had the data protection office at that business that was concerned about data protection, not just compliance, but actually upholding their corporate values. And in particular, they were concerned about feeding data into any kind of algorithm that casts a kind of generalized suspicion across their entire client base. So the solution there involved working with the business unit, with the technology department, with the data protection office to first of all design a technical architecture that would address some of these issues. And so in this instance, what that looked like was taking claims data and pseudonymizing it and only putting pseudonymized data into the fraud risk scoring algorithm. And then the output of that algorithm, a certain subset of the highest risk claims were then re-identified for kind of deeper analysis by actual fraud analysts. So human beings who are going and looking at other aspects of that particular case to detect whether fraud in fact took place. In addition to this, it involved delivering extensive documentation on the inputs to the model, on which model was actually used and how it worked, on the outputs of those models, and how the scores were computed. And delivering that to the data protection office and actually iterating with them until they felt comfortable with the approach that was being adopted. So when I talk about human accountability, I don't just mean the end user who's clicking the buttons. I mean the humans who are involved from many different parts of an organization who are all contributing into these kinds of projects, because they're very large and complex and don't involve just one person giving inputs. There are many people involved.
Yeah, I would like to add to that perhaps some clarifying things, because we didn't mention it before. When we talk about algorithms, of course, there's a lot of black box metaphor going on that. And to be honest, we can document way much better than with algorithms. What is happening, when it's happening, what is being changed, by whom, with which mechanisms, much better than for human beings. The reason why we have the construction of the legal person is the reason because we cannot identify that as easily within companies when human beings are making decisions. So it's not that black box as we think. There is a lot of ways to understand by analyzing input and then output and so on, even the most complicated algorithms. So that's for the starters. Then, of course, algorithms machine learning algorithms might change a bit in their design, but it's not a fundamental change of the design. So it's not a free-floating thing that starts being blonde and ends being brunette. It's still on the same type. That's the second thing. The third thing that I also want to add, machine learning and artificial intelligence do have an anthropomorphizing semantic, meaning it evokes or it awakes expectations about these mechanisms, these automatization processes being human-like. They are not. They don't make decisions, because to make a decision, you have to have a will, you have to have an intention. Those systems do not have that. So when we talk about liability, we cannot say that there was an intention in the machine to do X or Y. The intention has been taken before by a very complex network of people involved in this process. And what we have is a gap between this decision being taken by people and then the decision being executed, not by people, but by a machine. But those are two different things, and we need to be aware of that when we talk about liability. And the fourth thing, and the last thing that I want to clarify here is we need to have, when we talk about algorithms, we put everything, it's like goulash. We think an algorithm is an algorithm is an algorithm. Yes and no. We have top-down algorithms where the designers know exactly what is going to come out and are very much in control of the process. And we have bottom-up algorithms where, of course, the designers cannot know what is going to happen because it depends very much on the learning environment of the algorithm. And those type of algorithms have other requirements from the ethical point of view than the first type of algorithm. So we need to be more precise when we discuss about this. Thank you.
Thank you very much. So we have at least 2 questions. And please also give the mic to the lady in the back. Yes, she was the first to raise her hand. So.
Yes, thank you. I have a question for Kyle. I'm the DPO of an NGO, and Article 38 of the regulation requires that in the performance of my duties, I adopt a risk-based approach. So I'm going to ask you a couple of questions about how you assess and manage privacy risk at Palantir, keeping in mind that you are a major factor of risk for mine, because we provide IT infrastructure services to other NGOs. These are sophisticated data subjects, and the question of what is done to the data and how it is processed basically always boils down to the type of processing that's done by Palantir and its competitors in the business. So my first question is, at Palantir, what is, I imagine you do privacy risk assessments, what's your tolerance for residual risk? And the second question is, obviously you audit algorithms for fairness and discrimination. When you work for private clients, obviously I'm not addressing your national security side of the business, because that in Europe as in the US, it's outside of the purview of legislation, so it would be futile to address that. So I'm asking that question of you only when it comes to private clients. Can you give us a general idea of what model, of what fairness and privacy model you use when you audit your algorithms? Thank you.
Okay, and then we have our final question.
Thank you very much. Thus far we have been talking about algorithms that are based on personal data, but there's also the option that data are anonymized and then algorithms are used on non-personal data. What kind of protection, but the effects are the same in terms of discrimination, in terms of potential biases, etc. Automated decision making. Do we have a legal framework in your opinion? Does the current legal framework in your opinion address this option? Because the general data protection regulation does not concern non-personal data. Secondly, I'm wondering whether we could use private law, whether private law could come into the picture and can help us. And here I have a pressing question or issue, Could we try to opt for a solution whereby we automatically invert the burden of proof whenever an algorithm is part of the question? Thank you.
Thank you. So we have 2 minutes for each question. I propose that we start with the last question, and who would like to respond? Lorena, you can start.
Yes, well, thank you very much for that question. No, we don't have legal instruments because non-personal algorithms using non-personal identifiable data are algorithms that usually manage collectives. So you will have the situation that you won't have a single harm at an individual level. And that is a problem in a democracy. Why? Because democracies only understand individuals. And from the dogmatic point of view, they operate by granting individual rights. So when it comes to the collective perspective, democracies feel uncomfortable with that. They don't have legal instrumentarium for that. They have, in some democracies, they have some sort of corpora, perhaps, with regards to climate. But it's very rudimentary, and that is going to be the problem from the legal perspective, and that is going to have to be addressed within the next 10 to 20 years, in my opinion.
Just a small comment. Not all problems are data protection problems. There's privacy beyond data protection. And secondly, some of the so-called algorithm challenges that are being discussed are actually privacy problems. For example, things like filter bubbles on social media, etc. It's my position that this is a direct consequence of the fact that online spaces are based on massive data collection and profiling and are geared towards your assumed interests. So the core of the problem is that you're being profiled. So we maybe shouldn't talk about the newsfeed algorithm, but about the underlying logic behind the problem.
Okay, Kyle, do you want to respond to that
Sure,
question?
yeah. So a few comments about managing privacy risk. I think this is actually a field where there's a lot of room for innovation and improvement. So there are several different dimensions to this problem. Certainly, when it comes to managing risk at a particular client, under GDPR, our clients will be required in many cases to draft DPIAs, and we will be helping support them in the drafting of those DPIAs. So that is, again, a collaborative process. There's also, I think, several inputs that go into how you think about risk. So, I mean, risk, strictly speaking, is going to be a function of both the probability of an outcome and the magnitude of the impact. The challenge is how can you actually quantify those to the extent that you can reliably and consistently compute risks that are comparable across cases. And I think if you look at some of the work that's been done by NIST, the CNIL put out a framework on privacy risk management. They're really wrestling with this problem of how irreducibly qualitative a lot of these impacts are. And so I think having metrics that are comparable across cases is a really hard problem, not necessarily an insurmountable one, but one where I would hope more attention will be paid. And certainly my team will be paying attention to it and trying to innovate in this space as well.
If I can add something on step behind before non-personal data and collective interests, etc. Maybe we have an element that we often underestimate, and it's unfair commercial practice. You know, we have a directive. The Federal Trade Commission in the US is doing so much from that perspective. You don't need personal data for that. You just see the impact on consumers, and you understand effects, and you react to that. So it should be a framework that should be integrated with privacy and personal data protection in this filter bubble, etc. So apparently time is finished. So it was a very, very interesting discussion. Thank you very much for these wonderful speakers and your very interesting participation and questions. Thank you.